I want to call to order the session of the Special Committee on the Family Court, the subcommittee dealing with perjury. And I want to welcome all my committee members and substitutes for being here. Appreciate that. And again, I apologize. I know we had an earlier meeting that where we didn't have a quorum, and it's unfortunate, but we're all here today. So before we begin, I'm going to ask everyone to please stand and join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right. So the way I would like to proceed is this. We've dubbed this as a sort of work session, but if there are people who would like to be heard at the beginning, I'm happy to do that with a couple of caveats. First of all, I want to make it clear to everyone, we are not going to be retrying any particular cases. We have no authority to do that, and we're not going to do that. Secondly, the issue here of the charge of this subcommittee is the issue of perjury. And I guess what I would say is, for purposes of moving this process forward, let's assume that there is an issue of a problem with perjury in general or in family law cases. Let's assume that that's true. I think there might be a question of the extent of it, but let's assume that that's true. What I would like you to direct your comments on, if you wish to be heard, is what do you propose is the solution for that? Tell us what you think, how the law should be changed, in your view, to address that issue. And the last thing I would say is I'm going to limit people's comments to 3 minutes. So please get to the point. Tell us what you think the way that the law should be changed to address your concerns. So with that, I'll call. Sir, would you like to come up? Oh yeah, and do we have pink card? Oh yeah, if you wouldn't mind, you can, sir, you can tell us what you want to tell us first, but then just fill it out before you leave, if you would, please. Thank you. And anyone else who wants to be heard, I'd ask you to do the same thing.
So my name is Uday Karim.
There you go. Thank you.
Okay, it's good. So my name is Uday Karim Balasani. I live in Brookline, New Hampshire. So I know that just to confirm, no specific details about what I believe are examples of why we need the law change, right? So here's something that occurred that I believe of why I'm asked of the type of law that's required in family court, or is that okay?
Right. I would like you to focus on what you think. What you think the solution should be to if there's a perjury problem. What should be the solutions?
Absolutely. So I would say Layer 1, the New Hampshire Family Division Circuit Court rules specifically state that rules of evidence do not apply, right? And there's a lot of discretion when it comes to what that rules of evidence is. The standard for rules of evidence, obviously we know, have different kind of standards, right? So you have your very basic probable cause that's not enough to make a judicial decision, but it is in a criminal scenario potential to pursue charges, right, in investigation. We know there's preponderance of evidence, and we know that there's beyond a reasonable doubt. Family courts are generally preponderance of evidence. However, there is a conflict between no rules of evidence and preponderance of evidence. This has been something that's common across a lot of cases, so I think that's number one. Number two, how are we making sure that folks like guardian ad litems, who are technically under the law expert witness testimony, right, not being treated as 100% truth. What's happening a lot in family court is that the wide discretion afforded does not have a basis to determine what is the approach judges are using to determine credibility, right? So I'll give an example, especially where this becomes really problematic. And I'm open about this, so I'll share with you. I'm autistic. My wife has ADHD, right? So neurodivergence is very, very important to understand how people come across. Judges are using credibility determinations based on very clearly what's stated often: demeanor, behavior, eye contact, all of those things at disadvantage, because there's not enough, and this is where the Diversity Inclusion Committee actually will be huge for making sure that we understand how judges are being trained to understand how to use that power. That wide discretion is problematic when you do not have an accurate measure. There's actually a Supreme Court amici curiae brief that recently happened due to the FTX collapse, right? So this is in the financial crime space, but that gentleman, Sam Bankman-Friedman, there was an amici curiae that was submitted that explains how neurodivergence manifests, especially in the court system. And I think that's important for New Hampshire family court system. The next thing is, I would say, attorneys. Are attorneys properly trained to make sure that they understand the difference between candor towards a tribunal, right, and their duty? The problem that I've seen today is attorneys do not know the line of candor towards a tribunal versus when you're zealously advocating for your client. And when that line is crossed, and that line is different in criminal for an attorney, as a criminal defense attorney, for example, versus in family court. And what I'm seeing is that the criminal defense attorneys who are also coming into family court are using criminal defense candor towards the tribunal standards and impacting family court, right, where that does not apply and judges are not holding that accountable. So again, I can't go into those details in 3 minutes, but I would say really understanding how does candor towards a tribunal manifest. The next layer of that is judges also have a responsibility under the Judicial Code of Conduct to make sure that they are actively reporting issues such as professional conduct issues, whether it's to the Garden Ad Litem Board, whether it's to the ADO. So do judges have a good view in what is the line of candor towards a tribunal? When does that go towards breaching that? When does that go even further to potentially being criminal, right, to say perjury? These lines, it can't be one, is it perjury or is it not? It has to start with, well, how do we determine credibility, right? That's the most basic. From credibility, you go into, is there a candor towards a tribunal type issue manifesting here, right? From the professionals representing those individuals. Then you might go as far as, now is it perjury, right? And not just perjury as in the one part of Title 641, but any part of Title 641. Right? Because sometimes what's also occurring is you have this distinction of, well, technically they said this under oath verbally, that could be perjury or its misdemeanor equivalent. But then you also have a written statement that's the opposite, but the written statement does not match the verbal statement. And is that technically perjury? That's for a criminal court and judge to decide. But if you have these other layers behind it, it allows family court judges to not have to make a criminal court decision. That's for prosecutors and criminal courts to try. But knowing when to refer it by properly thinking about, have I made a valid credibility decision? Have I held the candor towards a tribunal standard, right? If you're not a lawyer, if you're a Garden Ad Litem or any other expert testimony, what are equivalent laws and standards that we can put in place that are like candor towards a tribunal, so everyone is held to that standard if you're a professional that's testifying, right? Then go to perjury.
All right. Thank you. Questions for this witness? Thank you very much, sir. Anyone else who would like to be heard? Oh, yes, and the pink card. Thank you very much. Anyone else who would like to be heard? All right. Yes, Mr. Velarde. And Mr. Velarde, if when you get a chance, I'd ask before you leave if you would fill out the pink card also. Thank you. Oh, I think you just turned it on. There you go.
Good morning, everyone. Thank you for your continued work on this important topic. My name is Thomas Velarde. I'm the Director of the Division of Public Protection at the New Hampshire Attorney General's Office. But for close to 25 years, I was a criminal prosecutor, primarily in the Stratford County Superior Court. And for 16 of those years was the elected county attorney. Part of my role as the one of the chief law enforcement officers for a county was to work with the courts for what we all understood was something that happened with some prevalence, which was the specter of perjury in court cases. That can certainly be in criminal cases. We're here today talking about family cases. So what I did and what I, upon information and belief, my county attorney colleagues did was we sat down with the clerks of each of the county superior courts and circuit courts and said, how are we going to handle these complaints when we believe that there has been something that actually qualifies as perjury? And I have to say actually, because perjury has an incredibly high standard of proof because there are 5 different elements that must be met. And in my communications with the public in regards to why aren't you going forward with a perjury case, it was typically because of those 5 elements. If you look at chapter 641, there are a number of crimes in there. Perjury is 641:1 because it is the toughest one to prove, and it should be with those 5 elements. I can go through those with you, but I think you're familiar with them. So we sat down with the clerks and were able to create a funneling system where when a judge recognized that something could be perjurous, it was sent to the county attorney because it's a felony. And whether it was family court or any other court, and I've received over the years referrals from all the different courts, so I'll stick just with the family court. What we would do is we would then assign it to an investigator. We would do interviews and we would do a full criminal investigation into whether that statement qualified as a perjurous statement. Again, if it was made knowingly, if when it was made with the belief that it was false. So it's not a mistaken statement. It is something that someone knows is false. It was made in an official proceeding. It was made under oath. And probably the hardest element is that it was material. That means it substantially affected the outcome of that particular controversy. And quite frankly, even after due investigation, it was often found that it might have been a false swearing or some other permutation of perjury. But if it's being reported to this committee that perjury is not being looked at or prosecuted or is underreported, it might just be because it's such a high mountain to climb for someone to be charged with perjury and then to prove that perjury. And it should be. It's a very serious crime. So I just wanted to attend this morning to thank you for your continued work on this, to offer my 25 years of dalliance into this issue. I've prosecuted perjury cases before. I've reviewed many more than I've charged, unfortunately, because of the high standard that perjury requires in order to charge a citizen of the state of New Hampshire with a most serious crime, which is felony. So I don't know if there are any questions based on what I've presented.
Questions for, yes, Representative Pearson.
Thank you, and thank you for taking my question. I want to list the 5 items that must be met. I have knowing it was a false statement. It was made under oath. It was made in a public hearing and was material to the case. What am I missing? Those are 4.
So you make a false statement. You must believe it's false.
You know it's false, okay.
It's material.
2,
It's
yep.
under oath in an official proceeding, and it's knowingly. The mens rea is not in there, but it must be made knowingly.
Mens res. Yeah.
The mental state.
Yeah.
So it's absence of mistake.
Right.
Yes, Representative Macbeth.
Thank you, and thank you for taking my question. I'm really interested that you.
Yeah, thank you.
Thank you. I really do appreciate your service and also that you have the way you talk about the judges referring to your office and investigating. Thank you for doing that. I'm wondering about the other crimes that are listed in 4641, like false swearing, the unsworn falsification and tampering with witnesses. Because those are also, I think, probably what the people that have appeared before this committee. It's not just, we're using perjury for a term that's actually a lot broader. Are those also crimes that may be referred to your former office by the judges, and are they also ones that you would have investigated? Thank you.
Absolutely. Thank you for asking that question, because perjury is a place to start, but then we would step down to, for example, 641-2, which is false swearing. If you line up the elements with perjury, you see that false swearing is almost the same as perjury, but you don't need to prove materiality, which again is a very big issue when we're talking about comparing statements with other statements that are made. So we would go through the whole panoply. I also neglected to mention in my initial statements that not just the courts refer these cases, but we would take any citizen complaint, at least in Stratford County, any citizen that complained and believed that they were not treated fairly by the court because their opponent had entered in perjurious or knowingly made false statements into a court record. We would still open the same investigation, go and pull the record and do those interviews and conduct a full criminal investigation. So, and again, upon information, I believe my other 9 county attorney colleagues were doing the same thing.
Yes. Questions, Representative Ball?
Thank you, Chairman. Just for clarification, where does like filing a false police report, if you make an accusation on a police report or you actually follow through, where does that fall? Because that's something that we heard quite a bit of people coming and testifying.
So that's covered in 641:4, false reports to law enforcement. And it can also be covered in 641:3, unsworn falsification. So these would then have, one element less, which was it's not made in official proceeding, for example, or some other permutation. But those are step downs again from perjury, then false swearing.
Clarification.
Yes, follow. Go ahead.
So just to clarify, so you're saying it's not made in it wasn't made in a, how did you word that again?
An official proceeding.
In an official, but if the police record is brought in as part of the official proceeding, or it's questioned, or it's now becomes part of the testimony, isn't that then falling under the perjury? Because now it is being claimed in a proceeding?
If it's a statement that's sworn to and is material. So then if you're talking about perjury, so now you're talking about an oral statement from a report. Am I understanding your question correctly? So this false statement is made in a police report and then is sworn to under oath in an official proceeding and is material as a oral perjurous statement?
Yes, because the police report is then used as part of the court case, or it could be used as part of the where the child custody is going to be, or how things are going to happen within the family court. So it finds its way into family court. And I think that's what people came to testify is that, but now it was a false statement on a police report, but now it's being entered as part of the proceedings in the family court. And
Okay.
it's being then used to withhold children, sometimes from a parent.
If the false written statement through some colloquy with that judge, are you adopting that as your testimony here? Because the person would have to testify under oath that the written statement is their testimony in that proceeding. If that course of action was taken, then maybe that could qualify as a perjurous statement. But otherwise, there'd be 2 separate analyses, because if you're dealing with unsworn falsification, that's a written false statement, so it can't be oral. So it would have to be adopted as an oral statement under oath in an official proceeding.
So what is the penalty for filing a false police report?
That's a misdemeanor. It can be handled in the discretion of the prosecutor as an A misdemeanor or a B misdemeanor.
Other questions? Representative Smith?
Thank you very much. I'm going to expose my ignorance here. Can you tell me if there is any difference between the occurrences we're talking about now in a civil matter versus in a criminal matter? Is that the particular issue irrelevant if you're looking exclusively at the perjury?
Thank you, Representative Smith. No, it's the same rules for any proceeding. So criminal, civil, family, these laws would apply to any statement that is made in a false manner, and then with the other elements that are required for the particular crime.
That could I follow up?
Of course, yes.
We also have, over the year or more that we've been trying to sort out this can of worms, I don't know what else to say. We frequently hear reference to concern that the court in question does not use rules of evidence. And we've had very clear explanation of why the court and the individual judges consider that to be appropriate in the family court. Does that reality, when you measure the costs and the benefits, is it appropriate to conclude that not having rules of evidence in this court helps us get closer to our goal of justice?
Not having rules of evidence strictly applied in family court seems to move the needle in the direction towards being fair to folks who are so often representing themselves and don't understand the ins and outs of evidentiary rules. As a criminal practitioner, I practiced under strict rules of evidence, and I can tell you that after almost every criminal trial that I concluded, I was convinced that someone had committed perjury because you could not line up the testimonies, right? But the big part of the fact finder is to rectify those differences and those shades between two competing sets of statements and determine who was more credible. So I don't believe that in and of itself, the suspension or the loose application of the rules of evidence leads us to some sort of solution on this perjury issue. And I do think it's the fairer way to treat people, particularly not just in circuit court generally, but certainly in family court.
And if I could just ask one more question. The chair began this work session by asking for suggestions of how we could, or not we, how the court system could be improved to even better meet the needs of the citizens of the state. Do you have, without you conferring with the Attorney General or the Chief Justice, do you have any suggestions that you would make, perhaps just for us to consider, of changes that we might encourage?
You know, I recently had the opportunity to sit at the confirmation hearing for one of the most recent circuit court judges, who's a good friend of mine. And I really enjoyed his presentation in regards to why he wanted to be a circuit court judge, which was, you know, the importance of really listening to the litigants before you and making sure that you were hearing them. So that art of active listening and making sure that those litigants are heard and have an opportunity to speak. I think there are more and more judges who are being appointed and confirmed who are employing those techniques. And so there's not this tremendous wall between the litigants, especially pro se litigants, and our judges. That just in and of itself is going to help improve the public's perception of going to the people's court, which is really what the circuit court is, and no more so than family court, where you're dealing with really the most caustic and traumatic issues that families can go through. So I think that we're developing into a scenario in the courts where the judges are understanding more. We really do need to listen. We can't just call people up and be sitting 10 feet above them and demand that they state their case in very esoteric and evidentiary-based 5-minute presentations and really solve the problems of what families are going through. So I don't want to do too much patting on the back, but I think the family court's come a long way in regards to having appointed to it folks that understand the complicated issues.
I'm sorry, could I just do one
Yeah,
more?
sure. And
I
then
find
Representative Ball.
that interesting statement. I wonder if you could support that in any way, because a concern that we hear repeated again and again is that there are many fine attorneys who are being nominated and confirmed for these courts, but that does not mean that they have had any experience in the family court or any meaningful training about how the issues in the family court differ from those issues that are on the table in other courts.
Yeah, the training for attorneys has been changing quite a bit. If you look at the selections of continuing legal education classes, for example, it's much more in the vein of not the science of trying cases, but the art of negotiation and dealing with people in mediation, and many more courses in regards to what is actually going on in people's lives. You talk about substance abuse, mental health issues, the complications of multi-generational families, how to deal with all those kinds of issues. Those things, just in the 25 years that I've been practicing, those were unheard of just a few years ago, but now we're all being exposed to it and trying to understand that better in order to serve the people that we're coming in contact with.
And those judges who, or those individuals who are being nominated, have all been required to participate in those?
They're not, I don't know if they've been required to, but we've certainly been exposed to it, and there would have been an awful lot more opportunity for folks to be taking courses in those veins to understand what's really going on before them.
Thank you very much.
Representative Ball.
Thank you very much for taking my question again. Just for clarification, are you saying that you would support the one judge, one court, one judge, as opposed to having a family see multiple judges? Because you mentioned about the importance of listening. And if the case is moved from different judges, have they ever really heard the whole case? So that's the first part, is do you support one judge, one court? And then as a follow-up to that, then I would be asking, so one thing that keeps coming in front of us is that the judges in circuit court don't have clerks. So there's no one, even if they do start moving around, the families are seeing multiple judges, who's really gleaning through to remind the judge of the previous conversations and what could have been said? How is that going to happen if we have no clerk? So I'm wondering what your suggestions, first of all, how you feel about one judge, one court, and then also what do we do about the fact that how are we listening if the judge doesn't have someone help them to go through and glean through, especially some of these that, I mean, these divorce cases go on for years. Thank
Sure.
you.
Having been party in cases that go on for years, I always enjoyed having one judge rather than having to refresh a new judge in regards to what was going on in the last proceeding. There's certainly an efficiency to that, and there's also some comfort, unless that judge is not with you at all, in which case you would very much like to have a change in judges. But so there's efficiency to it. I think there's also a level of comfort that someone actually is, in a way, your judge. I'm not here to make recommendations or suggestions, but I can certainly share my own practice point on that. I would think it would be also disorienting for families to constantly see a different judge and have to retell maybe some of the traumatic things that have happened. That might be the shortest way for an inheriting judge to get him or herself up to speed on a case, but there's certainly a vicarious trauma there that by all means should be avoided. Your second question.
The second question was that there are no clerks for the family court judges,
yes.
and whether that's causing more harm because there's no way to get to remind the judges. I mean, when you have stacks this big, who's gleaning through that to remind the judge of, well, this is what was said and this is what was happening and we're seeing a pattern, or bringing those things forward to the judge?
Sure. Well, this is maybe a side symptom of as we are digitizing everything, we're asking judges to have, just as you have a screen in front of you, ostensibly they have the entire record at their disposal and can just click and point and understand all that and refresh themselves. That's the way it's supposed to work. It doesn't always, because of technology issues. It puts a lot of pressure on judges because judges are becoming more clerk-like as we continue to consolidate down and we're staving off staff. Judges are doing more in regards to having to run their own dockets and be clerks. So I think it's something for this committee and other committees working with the courts to keep an eye on, which is it's already difficult enough to make these decisions on cases, but to also have to manage all the electronic documents can be, I'd imagine, it would become overwhelming.
Mm-hmm. Thank you.
Of course.
Other questions for this witness? No, I'm sorry. Go ahead, Representative Macbeth.
So, thank you.
No problem.
Thank you for this is It's really a repetitive question, but it's since the people that are coming before us, I wanted to follow up on my colleague Representative Ball's question before. I think what I heard your testimony say, if someone, an individual citizen, were to come to you and say perjury or what they consider a false statement. I think when I was reading the statute, I was so surprised that perjury wasn't just a false statement, that it did have those 5 elements. And so really it's kind of the top of the hierarchy of these false statements. So if a citizen were to complain to your office or bring a complaint, then your office would investigate that. And if it didn't quite meet perjury, there are the other like 5 or 6 false statement crimes that could be applied. It might not meet the top, but there were other crimes that you would then investigate and prosecute. That's what you're saying. So citizens do have a way to come forward. Is that correct?
Absolutely, yes.
Okay. And if I could follow up.
Of course.
So you were saying your 9 other counterparts, you believe this is how they practice in their counties?
Yes, upon information and belief, we all were doing the same thing.
And so then that's a good question as the elections approach for people to talk to their county attorney about, or who's running for county attorney, to make sure that this is going on in their offices?
A very fair question. What's your responsivity to us trying to use a court and feeling thwarted by being able to do so, or at least being able to do so fairly? And if there are laws that would allow for that fairness to be increased through the possibility of the application of criminal offenses, what is your office doing to apply those crimes to my scenario?
Thank you. Thank you.
Other questions? So I guess I just have one question, Mr. Velarde, and I'm wondering do you have any sense or any suggestions in terms of the perjury chapter of the RSAs itself? Is there anything there that you think there should be some part of the statute should be changed, or there should be a new statute to deal with, some of the things we're talking about now?
Oh, thank you, Mr. Chairman. No, if you look at the chapter on its whole in regards to written or oral statements, it's pretty exacting, as it should be, because we're talking about criminalizing conduct and in some cases felonizing conduct. So we should be pretty specific, but it really does cover the vast majority, if not all, of the scenarios that I've seen over the years of competing statements. And was a mistake made in one statement, or a disagreement made between 2 statements, or did someone really make a statement knowing it was false? And we know objectively what the truth is. And so that third example that I just gave you is really difficult to discern and then prove beyond a reasonable doubt. And so again, back to my original statement, which is I think the underreporting of perjury, or people saying, no one ever applies the perjury statute, it may very well have been reviewed by someone, and they just simply felt that they could not meet that high burden. But the chapter itself really does cover what you would want it to have covered, which is, obstructing police officers from doing what they're supposed to be doing, telling untruths in official proceedings, either orally or through written statements. Those are the big ones. And I think the chapter is exacting as it should be, and does cover what we needed to cover. I've not seen any holes where I would say the legislature should look at X, Y, Z. It's all in there. It just needs to be applied. And then it needs to be applied, unfortunately, to facts that are so often incredibly murky. And that's maybe where the breakdown in the public's eye. I know from having conversations with folks who have referred perjury cases to me, and I've said, this is why I can't go forward. We've had to agree to disagree, sometimes heartily, simply because there's an evidentiary standard to charge someone with a felony for perjury that I simply did not feel could be met, even though the statements were 90 degrees from each other. That does not necessarily mean it meets all those 5 elements.
Yes, Representative Pearson.
Thank you, Mr. Chairman, and thank you for taking my question. In the other committees that are similar to this, we've been looking at the value of having a small booklet that outlines various things, especially for pro se litigants who may not know all these things. Would a brief discussion of what qualifies for perjury be helpful if it were added to this document so that before people say, wait a minute, that's perjury, why aren't they doing anything? They may already have the answer. I realize I'm leading the witness, but could you answer anyway?
I think any reference to the RSAs is always helpful. I will tell you that I actually teach this chapter of the RSAs to the new police cadets and break them down, and we spend a good deal amount of time talking about the difference between perjury, unsworn falsification, false reports to a law enforcement officer, and the differences between them so they can recognize them on the street when they're trying to discern statements in real time. So I just use that as an example of, it's helpful to understand what are the rules in order to apply. So I would have to say yes,
Thank you.
Representative.
Appreciate that.
Other questions? Thank you very much, Mr. Velarde, for
Thank you all
appearing. I
very
really
much, and thank you for your
appreciate it.
continued work on these important issues.
All right. Is there anyone else who wishes to be heard? Yes, please come up.
Good morning, Gail Drobat, Amherst, New Hampshire. Thank you for allowing us to talk today. I'm not really prepared because we thought there was no public testimony, but you guys have legislated the laws. There is no enforcement mechanism for these laws. 633 for interference with child custody. This would alleviate a lot of these problems for these parents. And I want to say I am not in family court. I haven't been in family court, but I'm involved with lots of parents that have been. And it is horrifying for these children to lose their childhood because these laws are not being enforced. You guys have done your job. The judiciary, law enforcement, they have got to enforce the laws you guys have made. It's not fair for these children. And if there is an abuse situation, that needs to be dealt with immediately. You can't wait 6 months with DCYF. You need psychological evaluation or domestic violence, child abuse evaluation immediately. They cannot go without seeing one parent when there is these false allegations. It is harmful to children. They have lifelong detrimental consequences they will not recover from. I mean, we come before you time after time and nothing gets resolved. There's a little fix here and there. You got to enforce the laws that you have already made. These families are begging you. I'm begging you. Like, I keep seeing these parents, the children. What about the children? I ask that all the time. What about the children? They don't get a do-over. Please do something for the kids. 633-4, again, enforce it. Make an enforcement mechanism. Charge them if you have to. Nobody wants another parent arrested, but if that's what you have to do, you have to do it. You can't keep giving them discretion, the judges and the law enforcement discretion. You are ruining children's lives. Please do something for these kids.
Questions for this witness? Thank you very much.
Thank you.
All right. Sorry. What's that? Well, I think I want to hear from Representative Gay or former Representative Gay. Yeah. Oh, can I get a pink card, please? Yeah. And Representative Gay, if you fill out a pink card when you're done,
Sure.
thank you.
Excuse me. Okay, Betty Gay, Salem. My concern is that some of the places where false statements are made are far more detrimental than, because they happen more frequently than perjury in court. Just as was just mentioned earlier, when people file false statements either to DCYF or to the police, and then they're investigated, and that usually means that the parent that they're filed against doesn't see their child for X number of months. That false statement, when it's found to be unfounded, that child and the parent they're separated from have been punished, but the person who files the false statement goes unpunished. And it turns into a pattern. For some people, they play a game repeatedly, and there's no punishment. So even though when we're talking about perjury, we're really talking about court applications, aren't we? But the most serious perjury occurs long before it ever goes to court. And it happens frequently. And it's a tool that manipulators use. So I would hope that we could apply some changes to the law so that we can address that kind of perjury, even though it's technically, it's a false statement, but there is no penalty for it, and it's used repeatedly, and it separates children from their parents multiple times. I'll just add another concern of mine, even though I'm sure it doesn't exactly tie to perjury, but it's been mentioned about one case, one judge. The very fact that family court is a law, that is an RSA. One court, one judge. It's in circuit court. That's an oxymoron. That means you're going to get a different judge. So I would like to see that fixed and applied, because it's just outrageous to pass a law that you automatically don't follow. I'm looking to see. Oh, the idea that in court, perjury has all these 5 requirements, and then it makes a distinction between written and spoken. I thought when you filed a written statement, that was legitimate. I thought that had the same weight as, I thought written and spoken filed both had the same weight. Apparently it doesn't. So if anybody's going to file a charge, written, I mean spoken, it sounds like unless they go and sign it, it doesn't have the same standing in court. So I'm kind of discouraged that there's 2 separate interpretations, or 2 separate weights to that you can't use a charge. Let's see if I can say it better. If somebody calls and says that they think something bad is happening, and it actually goes to court, they can submit a written statement totally different. So you can't say, oh, you lied and got us in court, because it sounds like the written statement supersedes the spoken statement. And so I find that I don't agree with that. I think that should be clarified, that if you're going to say something that causes a great deal of effort in prosecuting or investigating a person, and it gets pretty hairy to figure out if somebody intentionally did that or accidentally did that. I think people would be a lot more careful with their actions if they knew, if they could no longer say, well, I thought that, but yet they triggered a great deal of action that harmed the person they were accusing. So I apologize that all these are disparate facts or disparate concerns, but they are concerns that I think need to be addressed. And one of them is not telling the truth before you get to court can be a whole lot more harmful than waiting for court to file it. We're already going through a great deal of suffering because of false statements made to police and to DCYF.
All right.
Thank you.
Other questions for this witness? Thank you.
Mr. Chairman, would it be appropriate to ask the gentleman from the Attorney General's office to speak to the issue of false statements that result in a parent not seeing a child for a long time that are later proven to be false statements, and what can be done, who can do what?
Sure, Mr. Velarde, do you have if you have anything additional that you might offer on that?
Make sure I understand. Excuse me. Understand the question. It's statements that are made in official reports in regards to custodial matters.
To the police or DCYF,
Right.
and somewhere along the chain, a child is removed from the home from one parent, and that parent may not see the child for months, but later we discover the statements that prompted the removal were clearly false. What recourse does the aggrieved party have in that case?
So typically those kinds of written statements, if qualifying, would be covered under unsworn falsification. So that's a statement where it's a written or electronic false statement, which the person does not believe to be true, on or pursuant to a form bearing a notification authorized by law to the effect that false statements made therein are punishable. So if typically we've added language like that to most statement forms to say, hey, if you're going to put this on paper, no matter what it's covering, but certainly if it's covering, parental rights, you are swearing to what you're saying here. And there's a penalty if we find that you did not tell the truth. So that would be covered under unsworn falsification, which is applicable to any proceeding, criminal, family, civil.
Follow up?
Yes.
Okay, then the aggrieved party should next go where and make what charge?
So that would be a report to law enforcement with where law enforcement will then ask, so your local police department or sheriff's office, where that agency will ask for the supporting documentation, a notation to the docket number, likely will pull the written record to see what happened in regards to any other supporting documentation. So it would be up to the citizen who wants to refer this to bring the supporting documentation forward. We would not have, as we meaning law enforcement, would not necessarily have the best visibility into the matter because most of this is confidential. So there'd be some obligation to waive some of that confidentiality to pursue an unsworn falsification. So there are choices that have to be made. I should have said that earlier in my testimony, which is we do ask families to give up some of that confidentiality, and sometimes that keeps people from wanting to report as well.
This sounds like the river is trickling down to something very, very tiny. So they go to the local police or the local sheriff, who then asks for documentation. And what usually happens next?
So they take that documentation, then they will do an investigation in regards to whether the statement on the form was something that the person who made the statement did not believe to be true. So that's very similar to, that's one of our perjury elements, right? And that it's on or pursuant to a form bearing a notification that you must make truthful statements. So it's going to be quantifying, you made this statement, someone is saying that it's not true. Can we prove beyond a reasonable doubt that when you made the statement, you believed it wasn't true? Again, not a mistake. You made the statement on October 1st. By October 3rd, you realized that you had made a mistake because, and you retract that mistake. So that, there are defenses to this as well. But it's something that you made on October 1st. You knew it was false, and you're somewhat recalcitrant or consistent in maintaining the
Dilatory,
falsehood.
yeah. Then what?
Then it would be, because it's a misdemeanor, it could very well be prosecuted by a circuit court prosecutor. So prosecutors who are attached to the different police departments, that is likely what would happen. And then I am very well aware, my circuit court was the 7th Circuit. So in Dover and Rochester, I frequently saw unsworn falsifications being prosecuted by the circuit court prosecutors.
I want to go back to the word, it was frequently?
Frequently,
Frequently.
yes.
Once again, so many people who are upset that their children were taken away, they didn't see them for a year, and everybody knew that what the statement was a blatant lie. Maybe they don't know the ropes on what to do next, but I'm hearing a lot of grumbling of there was no justice here. There was a clear lie. Nothing happened. Maybe they don't know what to do next. Maybe this should be in a guidebook or something.
Yeah, and the grumbling could come because there's a big disconnect between this separate track that we're talking about, which is now we're going to criminalize the false statement on a form, go into criminal court, wait for that case to get resolved, and then go back to family court and say, look, that person lied. That we're talking about months and months and months. So, you know, the folks that are using these criminal statutes, or at least trying to, that is really more in the wake of what has already happened in the family court case. It's not something that is utilitarian in regards to navigating the family court. So I don't want to leave this committee with any impression that there's some sort of real-time justice or rectification of a knowingly made and believed to be made false statement under oath in an official proceeding. It takes a long time for these things to move through, especially through parallel proceedings, criminal and then going back to family.
And since people know that, they're not disinclined regarding making false statements because they kind of know it's going to take a long time, if ever. And even if it goes against somebody, they're still not going to get their kids back for a long time.
I don't know that they know that, but that is the reality. It
I think they
simply
know that.
takes time to get sorted out,
Okay, thank you, sir.
of course.
Other questions for this witness? Yes, Representative Macbeth.
Thank you. I actually had a different question, but I'm just curious if the allegation that people make false statement or individuals would make a false statement because they knew it would take a long time. I'm just curious, isn't that what judges are doing, is analyzing false statements? I know that my chairperson said that everybody knew it was false, but if the judge knew it was false, what would happen? I mean, in an in-court statement that everyone knows is false, is it the judge just do they have the discretion or ability to handle that without going to prosecution?
Sure, well, as the fact finder, that would be an easy fact to find. So he or she would have done that already. But then they would have that discretion to make a referral for sort of an extra punishment, which is not only am I going to find against you because I find you to be patently untruthful, but now I'm going to refer you for possible criminal prosecution for perjury or some other crime of dishonesty.
So if I could follow up with one more question.
Absolutely.
And I'm not sure it's kind of the statement we heard before, one judge, one case, and also what to put in the little booklet that if that's produced. What I've seen when people have individual citizens have complained about not having one judge, generally it's because they have filed an ex parte or for an expedited hearing. So I'm curious, do you find within just your county that, and again, I'm surprised how much you know about family court, but I appreciate that. I'm asking you to step out. Is it generally one judge for one case in these, scheduled hearings? And is it these ex partes that are causing issues, or maybe an expedited, or, and if so, is that something maybe to go in the booklet, exactly what is an ex parte, the definition of that and the impact that may have on some of your other, an individual's other issues? Thank
I
you.
appreciate the question. It's so granular that I'm not sure I can answer it. What I can answer maybe a little more broadly is because of the speed with which the courts are moving, because of the incredible overburdensome dockets, litigants, water finds a way, litigants find a way too to try to get into court. And so the use of ex partes for maybe things that ex partes were not intended for could be part of the issue here too. So, some instruction in regards to what should an ex parte be used for, because that is anything that's done on an ex parte basis puts a huge burden on the court to get that immediately scheduled, which means bumping other things. The circuit court has become a very busy place, especially with felonies returning back to it. So anything that can be done to try to streamline how the circuit court dockets can be maintained on a consistent basis is something that should be looked at.
Other questions? Seeing none, thank you again, Mr. Velarde. Thank you.
Okay, thank you.
Ms. Cregan, I do want to hear from you, but can I just put you off for just a moment, sir? If you want to come up very briefly, really briefly, to address some specific point.
Yes. So I actually love the conversation with various people that just occurred, because one of the things that it highlights is there's a concept of polarity management versus problem solution, right? So everything that that's discussed is how do you solve the perjury problem? What I would frame to this committee is we have two separate constitutional rights issues. When you talk about perjury and you talk about criminal law, you are now talking about Sixth Amendment defendant rights implicated, right? In family court, we have the 14th Amendment and due process, which fundamentally makes sure that due process has to be followed in order for your parental rights to be intact. And without that, you have a problem. So the question that about these false statements and what that means and what is the right statutory construction, is there the mental state, mens rea? They're all valid legal components, but what's occurring is you have a conflation of constitutional rights that are occurring. So this entire due process that was described is absolutely valid, right? And it's valid because in order to account for Sixth Amendment rights and defendant rights that occur when you're implicating the criminal system, you have to follow those things. That is a valid process if you're going to say someone did something beyond a reasonable doubt criminally. But that is a separate issue in terms of the polarity or the problem we're trying to solve in family court, is how do you keep a parent's 14th Amendment rights intact? So our entire statutory construction approach needs to account for what preserves 14th Amendment due process rights. So when a parent makes an improper statement, a false statement, do we have a statutory construction mechanism specific to family court proceedings under RSA 461 that impacts a parent's custodial rights when that can be proven? And how does that occur from a preponderance of evidence standard, not a beyond a reasonable doubt standard? Separate from, because today, the defendant rights from a Sixth Amendment perspective don't apply in family court because you're not under criminal charges, right? You have a combination of some weird amalgamation of a court of equity and a court of justice. Okay? So given that you're accounting for two separate statutes of court of equity and court of justice, how do you account for due process? So if a parent makes a false statement, do we have an opportunity for a statutory construction under RSA 461, parental rights and responsibilities? For example, there's numerous additions that have occurred that are still not being carried out in family court. As an example, if a parent makes an abuse allegation and they truly believe that and they pursue medical evaluations on that, the updated RSA as of 2018 or 19, if I'm not mistaken, states that parent cannot lose parental rights. However, case laws such as Miller versus Todd are still being cited contrary to that statutory construction. As of the last session, as of July 1st, effective bill signed July 29th, it says that reunification therapy and removing, a parent's right to see their children is prohibited. Okay? Now, are we going to see judges apply that law? So these statutory construction changes that are occurring, one, need to be thought about in the specific constitutional jurisdiction. Do we have New Hampshire equivalent of the United States Constitution that then goes down to statutory law in New Hampshire, right? That is clear to judges, can't be counteracted by case law, right? Because what's occurred is you have the statutory construction from a public interest perspective is why you created that statutory construction. All of the wonderful legal minds then add their case law to it, and that statutory construction has gone out the window. So what is our mechanism to fix that statutory construction every time that happens, if that is no longer serving the public interest?
All right. Thank you. Ms. Cregan, I wonder if you could come up for just a moment.
Good morning.
Morning.
Erin Cregan, General Counsel for the Judicial Branch.
Sure. And I'm just wondering if you could tell us, based upon your experience and your role with the judicial branch, is there anything that you see in this area of the issue of sort of perjury in family law cases where you think that there's some legislative initiative that we should undertake to address that issue?
There is nothing that the courts are requesting, but just as a member of the public, I do understand that many victims experience negative feelings working with law enforcement, trying to get the evidence that will be persuasive to law enforcement, and trying to overcome that reasonable doubt standard. And although our state's Crime Victim Bill of Rights is very focused on the process that victims get once a case is charged, their attendance of hearings, whether they have a decision in the plea, there is not necessarily as much legislative focus on what their rights are before charge. I do know that's something that the House Criminal Justice Committee is considering. I don't know that what particular avenues they're looking at, but to the extent that people do not feel as though they have enough transparency on what law enforcement is doing before the case is charged, or how they can interact with law enforcement in a productive way and bring their case forward and understand what's happening, that's something House Criminal Justice is looking at. I will say New Hampshire is probably one of the better states for this. We have high accountability in our public offices, and I'm sure that there are people who are reporting crimes in Chicago who have no idea whether that case is going forward, whether they've given enough evidence, or anything like the accountability that Attorney Velarde is describing, where he would personally meet with citizens and discuss with them their case. So I'm not sure that there is necessarily a very large improvement to make, but it's something that this is a very responsive government in New Hampshire, and the House Criminal Justice Committee is considering for folks that want to bring their views forward there. There may be some avenue that they would bring forward, but I think a lot of the frustration that victims of crime experience is gathering sufficient evidence and meeting that high standard of reasonable doubt. And that is a universal frustration of victims of crime, of all kinds of crime.
I wonder if you could, and I'm going to open it for questions in a moment, but I wonder if you could, on this issue and I know this is a little bit off topic, but made to the extent you can address it. This issue of the one family, one judge. Do you have any sense of where does that stand, so to speak, in the circuit court now?
Great question. So I believe it's right in the statute that forms the circuit court, that it is ambition of the circuit court to honor that one judge, one family principle. There is no failure of will in the desire to implement that principle. There are logistical challenges. One of the the broad set logistical challenges is a lot of turnover. We lost a very large public service generation of judges as they were coming up on mandatory retirement ages, and we are now confirming a relatively large generation that's just entering the courts, and that meant judges covering 3 or 4 different courts. Judge Boyle was driving anywhere he was needed to make sure that the courts are open and available, and a judge is there for litigants who have scheduled court cases. But I think we were very impacted by that changeover. People lost a judge they had appeared in front of potentially for years. A new judge starts. Maybe that judge does their first few months in Manchester, where there are other experienced judges that they can get advice from before they'll go to a court where they'll be the only judge present. So there's a lot of logistical challenge in that changeover, but there is no failure of will. Judges prefer to be on the same case, to know the case well, just as prosecutors prefer to stay on a case, and just as defense attorneys prefer to serve a client all the way through a case. It's not an experience that a judge enjoys, being shuffled from case to case. It has just sometimes been a practical necessity of making sure that the courts are staffed and the judges are available when the public needs them.
Thank you. Questions for this witness? Seeing none, thank you. Is there anyone else here that wishes to be heard? All right, seeing none, then I'm going to close the receipt of evidence part of this. And I guess I would turn it over to discussion about what, if anything, our recommendations should be regarding perjury, regarding this issue. Representative Pearson.
Thank you, Mr. Chairman. I would put in our recommendations the few items that were previously flagged as being worthy of inclusion in that booklet that's being prepared. Attorney Cregan and I have spoken of this on numerous occasions. She believes that there's a group that would be willing to work on this. But to me, many of the failures and some of the anger come because individuals, particularly pro se litigants, they're not lawyers. They don't know these things. And so they get angry because why was that done? Why was that not done? What should I have done differently? And I realize there is some information people can access ahead of time if they are going to go pro se, but it's been my opinion all the way that there can be something more available to people. So I would say the couples of things that we looked at, what are the 5 points of proving perjury was one of them. I forget what the other one was, but things people need to know ahead of time. Now, there's always going to be some people who are going to be angry for the simple fact that they lost the case. And they are unwilling to believe they should have lost the case, and no amount of reasoning will work. I also believe there's a number of people who would be mollified if they actually knew reasons behind things. So that would be one recommendation I would make for our report.
So some and this, I have to confess my ignorance in the sense that I'm relatively new to the overall committee. I was only appointed relatively far along in the committee's work. But if I'm understanding correctly, there's going to be, the committee has decided that they're going to recommend that there be some booklet or pamphlet presented that will contain certain information for family court litigants. Am I understanding that correctly?
Could we ask Attorney Cregan to speak to that?
Sure.
Good morning. I know that you've had a conversation with Judge Christo, and she has been a little bit more partial to videos that explain certain things to litigants. We find that they're watched. We have short videos on the court's website that explain certain things.
She's younger than me, that's why.
Perhaps. I do not know if that is it, but there was also a conversation we had about there are some things the courts can't advise private parties on because we are limited in our ability to give direct legal advice to the public. And I did have a conversation with the executive director of the bar, who is a former circuit court administrator, about she has a bit of funding for public education on the law. And I think often that public funding is on things that are extremely important, but aspirational, like, for example, general principles of constitutional law and state constitutional law. And I had suggested to her that maybe some of that funding should be used for providing public legal education on extremely practical topics, like family law, which the bar is not limited in the same way the court is in their ability to give general legal information to the public. That might be a way of disseminating more information for self-represented litigants. So there are a few things that we're looking at in terms of helping self-represented litigants to understand the court system, but we do have some restrictions as well.
Sure. Follow up?
Oh, yes. And then
You've been making a list of all of the things I've been asking to be in this encyclopedia, I trust.
I have an entire folder in my email.
I believe you do. And would it be appropriate if after the session is over, you supply me with this person's name and contact information so that I can speak and encourage what
With
you've been
Executive
doing?
Director Blodgett? Certainly.
Thank you.
yes, Representative Smith.
Thank you, Mr. Chair. What we've just seen is one more example of the incredible, hard work that the chair of the full committee has undertaken in this regard. But the actions that Chairman Pearson's talking about, I believe, are actions that he has taken independently, not in any way that are the result of the final agreed upon version of the committee report, because we don't have a final agreed upon version of the committee report. So kudos to Chairman Pearson for not sitting around and waiting, but taking action on his own. I have a couple of you're talking about Sarah Blodgett.
Yes, ma'am.
Yeah. Could you tell me why, since the Bar Association is not independent body, but is part of, or membership in the bar is part of the Supreme Court. How the bar could do things that the court can't do.
I think I'm trying to put my theoretical underpinnings in the issue, but the bar is a somewhat independent entity. It has a president, it has an executive director. It's not directly controlled by the court system.
So the difference, if I don't mean to interrupt this, the difference that I completely misread is the difference between membership in the bar and the bar association. Because you can, you cannot, New Hampshire differs from many other states where there is an independent bar. There is not an independent bar in New Hampshire. But you are saying that there is an independent bar association.
You have to be a member of the bar in order to practice in New Hampshire. And that wasn't always the case, and that isn't always the case in every state. And there can be competing bars. And by practicing, you are bringing yourself under the jurisdiction of the Supreme Court. But the Bar Association is not strictly managed by the court system, and they do provide legal education over a large number of areas.
That's very helpful. Thank you very much. And Sarah Blodgett would be an excellent person to carry out that role. All right, I'll let the rest pass for now. Thank you very much.
So I wonder if another, I don't disagree with the way you've explained. I wonder if another way to put this would be, yes, we have an integrated bar in New Hampshire and that you need to be a member of the New Hampshire Bar Association to practice law in New Hampshire. And the Bar Association is ultimately regulated by the Supreme Court, but the Supreme Court does not, at least historically, has not felt that it has a really sort of intrusive, this is what you'll kind of do on a daily basis sort of relationship with the bar. Would that be a fair statement?
I think that's fair to say, and I guess what I would say is constitutionally, the entire practice of law has to fall under the Supreme Court, but that does not mean everyone that is practicing law is managed by the Supreme Court. So the Bar Foundation the court is doing a lot of things that regulate the practice of law in the state, but that does not mean that the Bar Association is directly managed by the court, even though everyone there in some way might be disciplined by the Supreme Court for misconduct. They're still an independent actor, as many people who are practicing law are independent actors, even though they're answerable to the Supreme Court as the ultimate authority on the practice of law in the state.
And I mean, just give an example, just from personal experience. If your experience is any different than this, please let us know. But for all the time that I was a judge in New Hampshire, and for even the longer time that I was a member of the bar of New Hampshire, I never remember a circumstance in which the court ever, for example, had a view on like who should be elected president of the Bar Association, or was trying to, either directly or behind the scenes lobby for this candidate versus that candidate. It was always something that was the bar's, they were going to do whatever they were going to do, and the court would, congratulate whoever won. And I assume things have not changed in that regard.
No, they have not. The Bar Association functions independently.
Thank you very much. If I follow up? Of course. I'm so old-fashioned in so many ways, including believing in 3 branches of government. And I know I'm stuffy and all that, but so let's just accept that. I'm sitting on a legislative committee, not an advisory committee to the judicial branch. And while I might have lots of ideas about, and I do, about the way that the court could better function, including how we nominate judges, which brings in another branch of government. Nonetheless, I feel restrained in where this special committee on the family court goes. And what I see is that there is an important role for the legislature, where the legislature has, in fact, the constitutional and legal authority, although it might not have the financial resources, to address certain problems. I begin with the whole process for how judges are nominated. Well, I'm not sure what we can do about that. But I then can see one issue that's come up again and again and again. We expect family court judges to carry out incredibly difficult responsibilities, ideally in a limited period of time, which doesn't work that way. And I believe we need, at the moment, not necessarily to have more judges, but to have judges better trained before they sit in family court. And I wonder, and I don't know the answer to this question, of whether it is within our authority or not to establish certain requirements for as part of the judicial nomination process. My guess is the legislature can't get involved in that, but I wonder about that. I then go to where judges are appointed, confirmed, and serve. And I believe very strongly that, and we've talked about this a lot, that there has to be a lot more and regular training. Again, I don't think that the legislature can direct exactly what the content of the training is. But I do believe the legislature could say, although albeit not in a time when all the available money has been spent in advance of the biennium, that there is going to be an appropriation to be used specifically and exclusively for training on a regular basis. I believe that it is appropriate, again, through the budget process, to insist not on more judges, but on more clerks and support staff, and to have money that must be used for that purpose and cannot be transferred. What I'm taking too long to say, I know, and you're all getting restless, is that there's very little that we can do other than educate ourselves about the genuine concerns that people have about how the court system operates. There's little that we can do in the legislative branch, but there are things we can do. I think money, when they say it's not the money, you know it's the money, for education, for training, for support staff. All of that, I think, is a role that we can play. And to the extent that the work that we've done for over a year now under Chairman Pearson's leadership, where we have identified real concerns, I think that we can talk about those concerns and present them as something that that bears watching, so to speak, but understanding that it's not within the power of the legislative branch to control what the judicial branch does. So I don't know if that makes Chairman Pearson unhappy or not, and I don't want to make him unhappy.
Are you unhappy?
No, I'm not unhappy, and thank you so much for the kind remarks. We had a lot of conversations, and we were very much, I can't think of the technical term. I know in cahoots with each other is neither in law French nor current French.
Collaborative, perhaps?
Collaborative, thank you very much. There's a word for me to learn now. And we had a lot of conversations. We came in as an outside pair of eyes, and we went back and forth, and a lot of things happened, and that's wonderful. I'm not sure how much of that will ever get into the final report of the special committee, and how much of the final report, which is not an LSR, it's a report, how many of those items will then become LSRs in November. But I very much appreciate the collaborative effort with the judiciary and amongst ourselves, and a lot of good things took place. So I'm not unhappy. Thank you for asking.
May I make a comment briefly?
Of course, absolutely.
I have no wish to prolong your proceedings, but I just want to say that this is an extremely dedicated, hardworking, and conscientious group of legislators, and we have received a large number of excellent observations and suggestions. And I'm thinking even of, we're doing a pilot program that starts in January, which will have guardians ad litem. We have received federal funding for guardians ad litem to get appointments in 4 different courts when they demonstrate indigency. Which is part of a suggestion, a conversation that we've been having in this committee. We're doing a pilot program on text notification that we're looking to potentially broaden to some family courts based on some of the questions that some legislators have had about notice and an email notice being missed. This, even if it is not a question of whether there is a bill that needs to be brought forward, the observations, the work that this committee has done is so appreciated, because the courts want to work for the people of New Hampshire. We want to do the things that work and serve the people of New Hampshire. And so your interest in doing that and bringing forward these suggestions is so appreciated. I don't find you to be the least bit stuffy or old-fashioned, Representative Smith. You have had some very, very perceptive observations, and we have appreciated them.
See, I missed the opportunity. I was going to say objection, facts not in evidence, but I missed the time.
All right. Any other questions or comments to this witness? Thank you very much for being here today, Ms. Cregan. I really appreciate it. Yes, Representative Macbeth.
So thank you. So you had asked about recommendations from the committee. I want to underscore what Attorney Creedon has said. I mean, the conversation has been very valuable, and I think that the court is responding to things, and the public responds to things, and we individually as members, even if we are not making an action item recommendation. I want to say personally, I'm very grateful to be on the committee. I think I didn't understand the nature and frequency of false statements that are being made, or that the citizens feel they're being made. And I'm understanding that a lot better. But when I then go to the statutes, and when I hear the testimony from the Attorney General's office, or from Tom Velarde in his previous career, I really see that the statutes are very significant. I mean, I think that, perjury is the, hallmark, and then there are other false statements that are impacting the family court, but I think that they are addressed by not only by the statute, but by court rules that allow the judges themselves either to not hear evidence if they don't want to admit, if people aren't providing, like if you don't provide financial information, then you can't contest the financial information on that point, by an opposing party. So I do appreciate that. I also, the false statement, I'm not a member of the Collaborative Law Alliance right now, but that is that's legislation that we will be considering this year in the House, I believe, and it's collaborative is a type of mediation that has a mental health professional as part of that group. And some of these false statements can be addressed during that process. And you have a mental health counselor really trying to help people gauge, is it a lie, or is it a statement you don't agree with, and how we can address that immediately going through the process. And I think that in my experience, whether it's arguing with my adult children about incidents of their childhood, it's not that I'm lying, it's that our truth is different, our perspective was different. And again, that's not always the case, and I'm glad we have law enforcement and statutes. But my recommendation really for this committee, there aren't any action items. I think we've had a lot of information. I think that the judicial education and attorney education, public education, I mean, who could not be for that? And I wanted to, there was a comment earlier about neurodivergent witnesses. I think that's very accurate. I think that the bar does have some education on that. I don't know if judges, I assume that they do, but that's critical. And that was a good point of the standards of credibility that we're using. But I don't think those are action items. I think that we've talked about it. We've got the district court representative here, and just keeping the dialogue open. It's an honor to be part of this committee, and I do apologize to those, my members, the chair, that I was not here at the last meeting and that there wasn't a quorum. That's a very humbling, embarrassing event in my life. But anyway, I hope that we can move forward positive on this. Thank you.
Yes, Representative Paul.
Thank you, Chairman. I appreciate what everybody has said. And I just, as I'm sitting here and having heard so much testimony over the last 2 years, one of the things that we found when we went into the courthouses is that there wasn't necessarily a fairness from one courtroom to the next, depending upon the perspective of the judge. And I'm not finding fault with anyone. And we did put legislation through that would address that. To make sure everyone was on the same page. But where I'm coming from is that necessity to make sure that regardless of which courthouse a family goes to or which judge they see, they should be coming out with the same outcome, regardless. If everything is the same going in, it should be pretty close to the same coming out. And so what I heard was that there was, I think, correct me if I'm wrong, that in the one courthouse, they may follow through with a false statement and there may be a misdemeanor or there may be something. My curiosity is that happening across the state? Is it happening and following through in all of the different courtrooms that when a false statement is made, is it being followed through, or is it just in that one particular court? I think that's where my head is always, is to make sure that we have fairness across the board, regardless of which courtroom or which judge a person walks into. So I'd be curious to know in each of the cases or each of the courtrooms, how many of those misdemeanors for false statements, how many of them are made? I would, if there's a way of getting that information, I'd be curious.
I'm sure we could get information about like how many false statement charges were brought in various counties, and I don't know whether we'd be able to get the information of who made the referral. But one thing I think it's really important to understand is that the judges, the whole thing that judges get paid for is to make decisions about a large part of which is what actually happened. And often there are conflicting versions of what happened. In fact, if everybody agreed on what all the facts were, there wouldn't be a case in the first place. So there are often conflicting versions of what happened, and that's what a judge gets paid for, is to decide what happened. I think what is often overlooked in this is that the basic remedy for false testimony is that the judge doesn't believe the testimony. That's, whether or not, it would seem to me, I can, having spent 18 years as a trial judge, there were numerous times when I didn't believe somebody's testimony, either because I thought it was they were mistaken, or they didn't have sufficient opportunity to observe something or whatever, or sometimes because they were lying. But what I would do, and I think what I'm sure other judges would do when that happened, is you're not going to make a decision based upon something that you believe is false. And so that, it seems to me, is the basic remedy for somebody who makes a false statement. Now, if it is a situation where there's a really blatant lie, that it seems pretty obvious that it will be able to be proved that it was a lie, and it's worth making the referral, sure. But I guess I would say you would make the referral. But I guess I would say, in 18 years of being a trial judge, at a time when we were doing family cases. It was all the Superior Court handled all the divorce, custody, those kind of cases. I probably made a referral to the Attorney General or a county attorney maybe 2 or 3 times. I mean, all those years, and that's not because it was only 2 or 3 times that I thought somebody was not being candid with me. It was just that it's not really worth it. I wasn't making a decision in favor of somebody that I thought was not telling the truth. And most of the time it wasn't really worth it. And particularly in family cases where there's a high level of conflict, unless it was really absolutely clear to me that it was worth making the referral, I often thought, look, to now send a referral so that one of the parties to this family case is now, in addition to all the other things that they're dealing with, they're now going to have to face a criminal charge. That is not going to help this family. And so very often I would end up, I'd make my decision based upon what I found to have happened without sort of, complicating everybody's life by making a referral for some kind of criminal prosecution. And I think I made the right decision in handling it that way. And I suspect that most judges would adopt the same view on that it really needs to be very clear that there was a deliberate lie that was on a serious matter, and it was likely that you were going to be able to prove that the lie occurred and it was material and all the other elements were met, and that the benefit of doing that outweighed the detriments, and that was often not the case. Yes, Representative Smith.
Thank you, Mr. Chair. Let me ask you a question, and I don't know which hat you should put on, but put on one of your myriad hats. Maybe we haven't been going about this the right way at all. Maybe the question we should be asking is, do these cases belong in a court at all? Is there another way, a better way, that we can acknowledge the state interest and find the tools necessary to protect every member of the family, understanding our particular responsibility to children, and not use a civil court process? Is that throwing the baby out with the bathwater? I mean, do you see what?
No, I do see what we're saying. I guess. I mean, this is, I speak only for myself on this. I guess I think that that you could do that. You could certainly have a non-court kind of administrative process by which you would do this. But I think it would seem to me that I'm not sure you'd gain very much, because I think the issue is, in a divorce or where there's a dispute about custody or something like that, there's a dispute. I mean, people are not in agreement. And so when people are not in agreement, who should have custody of the child? When should the custody be there? Should there be some restriction? People are not in agreement. Whether it's a court or an administrative agency, somebody is going to have to make that decision. And I think you're sort of back to my concern would be, if, let's suppose that you said we're going to handle all family law disputes like this in an administrative tribunal of some type. Well, first of all, you'd have to create that tribunal, But secondly, what I think we would be doing is 5 years from now we'd be having a hearing about whether why is there perjury in the administrative processes in the before the Department of Health and Human Services or whatever. So I think that would be part of my answer. And the other part of my answer would be I do think that whatever changes might be made, and I'm not certainly not suggesting that I think our selection process is perfect. I don't think that's true. But I guess I would say I think that the care with which judges are selected now, and probably I'd say going back to really when Governor Shaheen was governor, and I think she might have been the first one to begin to use the judicial selection commissions, and I think every governor since then has. I think that the care with which judges are selected is at least as good and probably better than the process by which administrative officials are selected. And so that gives me some comfort.
Thank you.
Representative Ball.
Thank you again. I just want to make a clarification in my question or my observation. I was not finding fault with the judges. What I was trying to make the point is what happens, as it was brought up, what's happening in the statements that are made before it even enters the courtroom. That's my concern. And that's where it's like, well, how do we keep them, just to put it in the words of the people who came forward over the last 2 years, how do we keep the weaponization out of the courtroom? That's the point I'm trying to get. When people are making these false claims, and that's why I'm saying, and then they find out they're false claims, what is the consequence? And that those are not being brought into the courtroom, as we said, can then drag out the court. And in the meantime, the parents are losing access to their children, or just the person who's had the false claims made against them, just what's happening to the reputation. And that's where I'm getting concerned. It's not that I'm finding fault with the judge or anything. It's how do we take the steps before it even reaches to assure that there's fairness for everyone. And I guess that's, and I apologize for if I made that sound like I was finding fault with the judge.
No. I didn't interpret it that way, and I don't, and in no way take offensive. I didn't interpret it that way, but I guess I think what I'm sort of saying is that even in the in the situation of somebody who has filed a complaint, and the claim is that it was false. It often is not. It is often not the situation that everybody agrees it was false. I think it's a relatively rare situation where the person who makes the false claim has kind of now. I'm not saying it never happens. I think it does happen, but it's relatively rare that person is saying, "Yep, I lied." It's usually somebody else is saying, "No, that was not true." And my child was taken away for some period of time because somebody, in this case, you're probably talking about somebody at DCYF, believed that it was true. But the person who made the complaint is in all likelihood is still saying it was true. And so somebody, I guess what I'm really saying, it's a decision. Somebody has to make a decision. Was this true or not true? And that is often not an easy decision to make. That's really kind of what I'm saying. It's not. I think one of the things that is a problem in this area is we get information from people who have a perspective from one side of a case, and they may be understand. I'm not suggesting for a moment that those people are lying. I'm just saying that when we're asked to make decisions based upon that, I think it's important that we factor in about what we're going to do, that there may be another side of the story that we haven't heard. And I think that's, whereas the decision maker in that, whether it's the court or DCYF or whatever, they often have heard the whole story. And so they may, I think we need to factor that in as to whether what action we're going to take based upon things that we've heard. We got to write a report. So I guess here's what my inclination would be in terms of a subcommittee report, is to say there's no question that perjury from time to time happens in family law cases, as it does in other cases, and it may even be true that there's more of it in family law cases, because those are, I would be the first to admit, those are the highest conflict kinds of cases. There's no question that the people, especially where children are involved, people are, that's where emotions can run the highest. But in terms of what legislative actions we can take, I have absolutely no issue whatsoever, Chair Pearson, with the idea of, providing more information to litigants. If we can, as I say, I'm a little bit late to the process of what all the points that you and Ms. Cregan have been talking about that would go into a booklet or pamphlet, but I certainly have no problem with having something be put in there concerning like what are the elements of the crimes that can result from somebody making a false statement, whether in court or in some other official proceedings, or documents that are filed with DCYF or whatever, as Mr. Velarde pointed out. And I also completely agree with Representative Smith on the advisability of having better training and educational services for judges, with the caveat that I think you also recognized is, I think this is going to be a challenging biennium budget-wise, but to the extent that that is something that is doable, I'm completely on board with that.
Mr. Chairman, I don't know if you took the opportunity to read the reports of previous committees like this one. I have, others have. I think the report that we will be voting on a week from Tuesday is something that will be looked at, will be cited, will be informational to 5 or 6 years from now when another special committee is formed. And much of what goes into eventually 7 different subcommittees, we've done 4 reports, 3 are in the process of winding up, is to say, we met, we looked at these things, here's some things we find should be known wider afield. Some of these are aspirational, some of them are educational, some of them may turn into LSRs, not from the committee, but from individuals perhaps on the committee or even outside the committee that we sign on as co-sponsors or what have you. So the report should really kind of reflect the work we've done here. And as I say, some of it is educational, I think. Some of it's aspirational. When the pot of gold has been discovered, here are certain things that we would now suggest we actually go do, and so on. So I think that's what we would need from this group before we adjourn, is a report that's brief like that, but has something to say, not just to people reading it now, but down the road.
All right. Other comments? So I will try to put something together, sort of summarizing what we have just discussed. And I know we're having final committee meeting on October 22nd, I think. Yep. And I'll make sure I circulate it to the subcommittee. You know, it'll be short and to the point, but I'll try to do that as quickly as possible. You know, I just would make one other point on that, particularly since we're focusing on perjury. I think that Representative Smith's point about the judicial selection and that kind of thing is really important, because it seems to me that there's a lot of things that I think training and education of judges is very important on. I'm not sure that the issue of perjury is one of those. And that's because it seems to me that the question of deciding what happened, who's telling me the truth and who's not, who's being accurate and who's not being accurate, who is lying, deliberately lying or not, I'm not sure that there's a lot of training, quote unquote, that you can get to decide that. That's really based on your life experience. I mean, you get that kind of training in raising a child, and when they say, you know, when you say, what happened, where did that cookie go? And you get an answer, and you know, over life, you begin to, and when you go into the grocery store and, you know, say, what happened to, somebody tells you, there's been a change in price and why or whatever. All those things in life are what kind of trains you to make those kind of decisions. And that's why I think, you know, as a very good colleague of mine, I'm really proud to say, my former colleague, Judge Conboy, would say, that's why most of the time it's a good idea for judges to have some gray hair before they get appointed, because they've had some experience in life and they're in a better position to be making decisions about who's telling the truth and who's lying and understanding human motivations. So that on the issue of perjury, I think that life is the best training for that.
So you will be pulling all of this together, sending it out to us for comments back to you. So the final report will officially appear on the 22nd, and we will then vote on it.
But the members of the committee will see the draft of that before the 22nd.
I should hope so.
I would hope so too.
All right, is there anything else that we need to discuss? I will try to get a draft out by early next week anyway. And I'll circulate it, you know, to the members of this committee. No, I have not.
Reading the interim report kind of gives the form of what the other three reports could possibly look like. They vary in length and intensity and so on, but they sort of have a family relationship to each other. So we have four interim reports, four reports in the interim report, and we will be adding three more, and they could be like unto it.
Oh,
perhaps.
sure.
Okay?
You know what, can you send those to me? Can you,
Well, that involves computers, so I'll delegate that to somebody.
all right, thank you. All right, anything else? Thank you very much. I'm going to close this hearing.